Mr. Williams, is that correct?
Yes, sir.
This is SU 2025 CR 115, State of Kansas versus Daryl Jahal Williams. Mr. Williams appears from the Sumner County Jail. Mr. Williams, this pending matter, you've had a warrant out for failing to appear in court. Looks like we've had a few different warrants and bond appearances. As you've previously been advised, the charges in this case include possession of marijuana, which is a Class B misdemeanor carrying up to 6 months in jail, up to $1,000 fine. Count two is possession of drug paraphernalia. That's also a Class B non-person misdemeanor, same 6 months in jail and $1,000 fine. And then count three is criminal carrying of a weapon. That's a Class A misdemeanor carrying up to a year in jail and up to a $2,500 fine. As you're aware, you do have a right to an attorney to represent you in this matter. If you cannot afford one, the court would appoint one upon proper application, as you've previously had a court-appointed attorney. Do you know what you want to do regarding this matter, Mr. Williams?
Yes, Your Honor. I was supposed to be paying $650 towards me getting put on diversion. That's where we were at last time I spoke to you guys. I don't know where. Last time we spoke, that's all we talked about. You guys had told me I had.
I'm not going to get into the meat and potatoes of this, but I'm guessing your diversion opportunity is gone because you've missed court, and you haven't taken care of it. I just need to know if you want an attorney and what you want to do regarding an attorney in this case.
I don't have an attorney no more with Austin.
Well, when you don't appear and a warrant gets issued, I have to have you reapply. It's been a while since you've applied. It looks like you applied in November of last year is the last application I have.
Okay.
Let me look at that.
Yeah,
Um, at that time, you were unemployed. Has your situation changed since then?
yes, sir. Yes, sir. I actually work at Logan's Land. And
Well, what you'll need to do is fill out a new application so that I can review that and appoint an attorney to represent you. If you still qualify, Mr. Fallsgraf would be reappointed, but I need to get that updated information and review it before I appoint an attorney to represent you.
yes, sir.
Um, your bond is currently set at 25,000 cash or professional surety. And I believe that's because your previous bonds have been, yeah, ineffective in keeping you attending court. You had a bond of 7,500. Is there a bond that you can make?
Yes, I can make a bond. Like I said, Your Honor, last time I didn't know that I had court. We weren't, that wasn't a thing. You guys just told me that I had to pay the
I'm
money.
not going to get into that with you because you stay in touch with your attorney and you know you have court. You've got multiple efforts here of trying to contact you and you didn't respond and you didn't appear. I will lower your bond to $15,000 cash or professional surety. Get the form filled out. I'll get an attorney on board if you qualify, and I'm going to continue this to June the 4th, 2026 at 11 a.m.
Okay, yes, sir.
Mr. Schmidt, is that correct?
Yes, sir.
Branch Schmidt, you've been arrested on allegations of violations of two statutes. The first is violation of protective order. That's a Class A misdemeanor that carries up to a year in jail, up to a $2,500 fine. And count two is a criminal damage to property, which if convicted, it carries up to 6 months in jail, up to a $1,000 fine. You do have a right to an attorney to represent you. If you cannot afford one, the court would appoint one upon proper application, and you can get that application at the jail. And I suggest you fill that out if you think you want a court-appointed attorney so that we can get an attorney appointed to represent you as soon as possible. I have found probable cause in this matter. I have set your bond at $5,000. I am allowing an OR bond. I'm going to set you for a bond appearance on June the 11th, 2026 at 9 a.m. Your bond has a condition that you're not to have any contact with Crystal Schmidt and not to be on or around the premises of 1477 South Springdale Road, Caldwell, Kansas. Do you understand all that, Mr. Schmidt?
Yes, sir.
All right. There's nothing further. This hearing's concluded. Is anybody from the county attorney's office on here yet? Will you take that to the clerk so they can get that OR bond out to the jail for him? That's Mr. Belt. Mr. Belts, is that right? Jesse? Mr. Marchinsky, I've got a bond appearance on a Jesse David Belts. He's in the courtroom. It doesn't look like charges have been filed yet. Are you needing some additional time?
Yes, Your Honor, those ones are still under review. I'm not going to make an announcement at this time, but I haven't made a charging decision on that one, Your Honor. I'm sorry. I would request 2 weeks.
Court will continue this bond appearance to June the 11th, 2026 at 9 a.m. You have that date, Mr. Belts? June 11th at 9 a.m. And if you think you want a court-appointed attorney, you can pick up an application, fill that out before you leave today. Okay. Oh, it is here. Okay, it is here. All right. Thank you. It's June 11th. Mr. Belts, he's writing it down at 9. Who else do we have?
She's here from 11 o'clock also. Kylie. You may just go down by numbers though?
Well, there's several here for Mr. Fallsgraf cases at 11. Is that correct?
Yeah, well, yeah, you got two. You got Kylie, who's behind me.
Give me just a second.
Francisco. He's here for a bond appearance though.
No, he's got a case.
Okay.
Give me just a second. I know I saw an email from Mr. Fallsgraf. There it is. Who did you say, Mr. Cisco?
Also
Mr. Cisco? Mr. Fallsgraf is asking for your case to be continued to July 2nd. He's getting a motion on file. Well, I say that, Mr. Marchinsky, he had said you'd need at least 2 weeks on his motion that he was going to file last night. But
I'm interested to see the motion. We've had some discussions about it. I will obviously need a little bit of time to determine. It's an execution issue. I don't think it's a Myers issue based on the
Right.
posture of the case. So it's kind of interesting as far as that goes. I obviously need to speak with Deputy Brown and figure out what efforts may have been made so I could make those reasonable arguments. So I don't object to the continuance at all. And
I think I would prefer to go to that July 2nd date rather than just 2 weeks, if you're okay with that.
let me see. Sorry.
I think
I'm
that's
sure that is more time for me is always the
right,
better. So
right.
I'm sure
And then
I
if
don't
we need
object
to
that.
schedule, or if you guys decide we need a special set that, we can always do it before that July 2nd date. I just was,
Yeah. Do we have is there, for some reason, I don't currently have anything on my calendar on July 2nd. Have we not scheduled any hearings for that day yet or not?
no.
That's insane.
So maybe it'll just be an Austin day, because I don't know that anybody else is going to want to be here that day. But I'll let him know you were here when he's over here, but I'm not going to make you sit around and wait to hear him ask for continuance. So you can check in with him in a day or two. All right. So July 2nd at 11 a.m. Yeah, it's Miss McCatherine. I'm going to call it in a second. That's SU 26 CR 84 Kylie McCatherine. Ms. McCatherine, it appeared that Mr. Fallsgraff's relatively new to that case, and so he's asking me to set it over to July the 2nd, and I'm going to do that. So you'll need to reach out to him in a day or two and schedule an appointment to see him. All right? Thank you. Who else do we have in the courtroom? Shiloh Chase. That's Robert Moody's case. He'll be here at 9:30. Oh,
I'm so sorry. You're moving a little quick. It's
That's
fine.
okay.
What day did you move Miss McCatherine to? I'm trying to dig
July
that.
2nd, July 2nd.
Okay, thank you. Sorry for that.
Mr. Chase, your attorney's not scheduled to be here till 9:30.
Thank you.
Brady, we can call Brady's case as soon as he gets on. Mr. Short, are you ready on your case?
Yes, I'll switch my computer around. I got Carson Horst present as well.
Okay, I'll call Mr. Dvorak's case first. That you know what you're doing.
Yeah, I spoke with Mr. Martinsky yesterday. We sat down and visited about this case and where we stand. Mr. Martinsky is going to, as a result of that conversation, is going to send me a updated written offer in writing that will hopefully get us closer to resolving that matter. So if we, I don't know, as far as the court's availability, but maybe a docket date sometime in June if that works for the state.
Like June 18th, that'd be about 3 weeks.
That'll work fine for me.
Fine for the state. Thank you.
We'll continue this to June 18th, 2026. Do you want 9:30, Mr. Short?
That works great.
And then you said you're going to be entering on Mr.
Yeah,
Horse's.
Carson Horse, I filed an entry of appearance late in the day yesterday. That's 26 CR 131.
Oh, I see it now. I see it now. Obviously, you're new to that matter. Are you needing to set that over, Mr. Short?
Yeah, I spoke with Mr. Griot and we have an arrangement on that case that I think we'll be able to journalize it. So if we could set it off for somewhere in the next 45 to 60 days, that would be ample time to get all that accomplished.
Do you want to go to July 9th?
I think I'm out that day because I turned 40 the next
You're an
day.
old man, Brady. You're an
I'm
old
not sure
man.
how I feel about that. I hate to say that, but
The 16th, that's a couple of days before my birthday, if you want to go to the 16th. We'll go to
the 16th would be fine. Like I said, it's
it
probably
may be journalized and it may be irrelevant. So we'll
Right.
continue to July the 16th, 2026 at 9:30 for journal entry or expected journal entry.
Thank you, Your Honor.
All right. Is that all you had this morning, Mr. Short?
It is, Judge. Thank you all.
Thank you. Okay, back to who's in the courtroom. Who do we have? Who else? Mr. Tabing, if you'll come up. This is SU 2026 CR 147, State of Kansas versus John Keith Tabing. Mr. Tabing, you've got several charges here. The first is a fleeing and eluding charge. That's a felony, level 9 person felony. What that means is if convicted, you face anywhere from 5 months up to 17 months in the custody of the Secretary of Corrections. Count 2 is a driving under the influence. First offense, that's a Class B misdemeanor carrying up to 6 months in jail and up to $1,000 fine. It does have a mandatory minimum 48-hour jail sentence as well as a mandatory minimum $750 fine. Count 3 is an attempted interference with law enforcement officer. That's a Class B non-person misdemeanor carrying up to 6 months in jail and up to $1,000 fine. Count 4 is a reckless driving charge. That is an unspecified misdemeanor, and the potential penalties for that are up to 90 days in jail, but at least 5 days, and a fine between $25 and $500. And then count 5 is failure to obey a traffic control device, and that's just an infraction. You do have a right to an attorney to represent you in this matter. If you cannot afford one, the court would appoint an attorney upon proper application. If you need a continuance to hire an attorney, I would grant that continuance. Do you know what you want to do regarding an attorney?
Filling out one for.
You're filling out an application. Okay. We'll set your case to the side here. Once you get that done, provide that to the deputy and I'll review it. All right. Who else? Do we have others on the screen? I kn- I don't think is, yeah, I'm pretty sure that's. Yes, even though we are, it's after 9, so I'm gonna go ahead and start calling these other summonses. Looks like we have SU 2026 CR 130, State of Kansas versus Reginald Raymond Cooper Jr. This looked like he appeared last Friday by Zoom, and he was advised of court being tomorrow at 9. So I guess we'll call it again tomorrow. SU 2026 CR 122, State of Kansas versus Kyle Adrian Walker. State appears by County Attorney Larry Marchinsky. Mr. Walker does not appear. He appeared by Zoom 2 weeks ago. I gave him 2 weeks to hire an attorney, or he must appear if an attorney has not been hired. I'm not seeing an attorney has been hired, and he's not present. State have a request.
Judge, it looks like Mr. Walker's currently out on a $2,500 OR bond. The state would ask that you consider revoking the OR bond, issuing a warrant for, and based on these circumstances, I would defer to the court, but probably just 2,500 cash or professional surety, or being that he has been here, knew he was supposed to be here again, I guess I'd ask for perhaps $5,000 cash or professional surety.
I think I'll just leave it at $2,500 cash or for professional surety. I'll authorize a bench warrant in that amount, and we'll get him here and see him. We'll go through who's here and wait and see. Is that Mr. Tabings? Mr. Tabing, if you'll, is it Tabing or Tabbing? Tabing, if you'll come back up. Mr. Tabing, I'm going to find that you qualify for an attorney in this matter. I'm going to appoint Joseph Favre to represent you in this case. I'm going to need to continue this for a period of time to give him a chance to get the paperwork and you a chance to visit with him. We'll give you Mr. Favre's contact information. Can you, oh, do you have Odyssey yet? Yeah, give me just a second. I'm going to look and see when he's available. Looking to see when he's going to be here next. Mr. Marchinsky, you don't happen to know the next time Mr. Favre is going to be here, do you?
He's going to be here today. Maybe we just set a date with him then. I don't know his next date after that, but I do know he's going to be here today. So maybe I don't need that Mr. Tabing has to come back, but maybe we set a date with that. I'm with you probably 30 days in the future, but
Yeah, I think I'm just going to go ahead and kick it over to the 25th, and then if Joe's not available, he can let me know. That way I'm giving Mr. Tabing a date here. I'm going to continue this to June the 25th. The deputy is giving you Mr. Favre's information. He'll know later today that he's been appointed. So you'll need to contact his office in the next couple of days. Give it a day or two, maybe early next week. Contact him and make a time to see him. It will be at 1:15 on that date, on June 25th.
Thank you, Your Honor.
All right?
Yes, sir.
It's important you stay in touch with your attorney.
Thank you.
All right, thank you. Still nobody? Who is Google Pixel 7a? Can you send them a message and ask them to who they are or? - 74 degrees and humid. Like, what's that set on? It's 74 degrees up here and humid.
72. Can you crank it down?
Please.
Karaki Ruanuma.
Who is it?
Karaki Ruanuma. Karaki
Got it.
Ruanuma. RWANUMA.
What? I wonder who keeps giving these people Zoom. Mr. Marchinsky, that's a bond appearance,
Yeah.
a DUI case.
Yeah. I'm sorry, Judge. We should have gotten a clerk to clean up. Mr. Griot's declined that pending evidentiary testing of the blood, breath, or urine. He did send the Leos a decline letter requesting that they get that evidence processed and back to us as quickly as possible. But at this time, the state's declining to file those charges until our evidence comes back. So I don't want to butcher his name, but he would need to be released on his bond at this point and be advised that he will be summoned in the future once that DUI evidence comes back.
You understand that, sir?
Yes.
Okay. You're free to leave. Thank you.
You're welcome. I mean, Makira.
Yeah, mute him. Do we have some other people that have?
They're attorneys. Yoder's attorney.
And we'll get back on the there's an SU 2026 TR 835, a Mackenzie Thomas Eubanks. That's a traffic matter. It's charged as a traffic matter. Is Mr. Eubanks present? State have a request on this. It looks like bond's $1,000 OR.
Yeah, Judge, this is a little bit unusual. He's actually subpoenaed to be at a preliminary hearing tomorrow afternoon, and that subpoena has been unable to be served. Little concerning for that issue. Based on all of that, I think I would ask that you consider revoking the OR bond, and I'd request a cash or professional surety bond in the same amount.
I'm going to allow bench warrant, forfeit the OR bond. I'm going to do a $2,500 cash or professional surety. Then I have a SU 2026 CR 136 Pete Wesley Scott. State appears by County Attorney Larry Marchinsky. It looks like Mr. Scott's summons went unserved. This is just a battery case. State have a request in this matter.
Yes, Your Honor. Based on the attempt, we tried to summons him, unable to do so. It shows to be an address here in Wellington. I would request the court, being that it is a Class B, just simple battery, the state would request a bench warrant in the amount of $1,000 cash or professional surety.
Court authorized bench warrant, $1,000 cash or professional surety. We'll take a short recess and wait for Mr. Moody to appear. Mr. Marchinsky,
Sir.
I just realized they handed me a number of bond appearances. I've got a Janelle Belts. Have you made a decision on that one yet?
No, that one's a little tricky as well, Judge. Obviously, you know, our
I
history
remember
with the Belts
reviewing the
family.
probable cause on that one, so.
Um, I would actually make the same request on Janelle's case as I would make on Jesse's case. I don't know that she's here, but that case is also a little squirrely.
Was that June 11th? I think we kicked it over 2 weeks.
I did, yes, sir. Yes, sir.
Yes. I'll do that. She had filled out an application and it's attached. So once, if a case is filed, we'll get counsel for her. I've got an Abigail Bram as well. That's another one that she's applied for counsel, but I'm not seeing that we've charged.
I'm pretty positive that is another one.
Do you want to go to June 11th with it as well?
No, Judge. Again, we should have gotten a clerk decline letter up. I apologize for that. It does appear that Greg reviewed this for me and he's prepared a decline letter. Let me see if I can't tell what the reason for that decline was.
I think that may have been a mutual situation. My recollection of reviewing the PC, I thought that might be a issue as to who did what.
Just I can probably tell you if it's a decline with prejudice or a decline with might have to come back type of a situation. But either way, we should have sent up a clerk decline advising that she needed to be released on her bond because at this point we have declined charging.
Okay.
If I may, I was waiting to hear back from the alleged victim in that case. I haven't been able to contact them yet.
That's fine. If we decline, you can make a decision later. The other one I have is Suzanne Gregory. I do know that charges were filed against Miss Lambert. I do remember reviewing that from this incident, who's the alleged victim of Miss Gregory's case. Did you make a decision on that, on Miss Gregory's case as it relates to that incident?
I have not, Your Honor.
Do you want to go to June 11th on that one as well?
If I could, sir.
And we had one more who's in custody, and I got a note that Mr. Schoenhofer's been hired to represent Mr. Axel Flores Lilanos. And I was just intending to call it when Mr. Schoenhofer appears.
He called me yesterday and advised that he was entering on that case. I told him that that's a fairly significant drug distribution case. I'm still reviewing the evidence on that one as well, but it is extremely likely that charges will be forthcoming on that sooner than later, depending on where we're at on the evidence right now. And Mark told me he was going to have to request a continuance because he wasn't available. And I am so sorry, Judge. I didn't ask him what date he wanted. I thought that he said he was going to log on early. I told him that you like to start early. So I thought he said he was going to show up before 9 o'clock because he had some other hearing.
His office let us know he was going to be logging on. He has another case on this morning. That defendant also has a case that Mark represents him on June 11th. We'll just wait until Mr. Schoenhofer logs on and we'll set Mr. Flores's case over as well as the other individuals. So I'll get these other bonds back to the clerk and we'll be in recess till Mr. Moody's on. Although I've got James Houston Bale. What's your name? Mr. Moody, are you ready on yours?
I am, Your Honor. Thank you.
Give me just a second. I know you've got Mr. Lowe here in the courtroom. That's SU 2026 CR 54, State of Kansas versus Vance James Lowe. State appears by the County Attorney Larry Marchinsky. Mr. Lowe appears in person, and Counsel Robert J. Moody by Zoom. Is there an announcement in this matter, Counsel?
May it please the court, Judge, I have received and reviewed the written and video discovery. Mr. Law, I did reach out to you this morning. If you can give me a call so we can get together and discuss all of that. I'd like to keep this on a short window if we can get June 11th, Judge, for another status.
Court will continue this to June the 11th, 2026 at 9:30 a.m. to review discovery. Thank you, Mr. Lowe, for appearing. I don't think, is Mr. Chase back in the courtroom? Mr. Chase, come on. Mr. Chase has been here a while and he was soaking wet from walking here. So this is SU 2026 CR 141, State of Kansas versus Shiloh Jader Chase. State appears by the County Attorney Larry Marchinsky. Mr. Chase appears in person and with Counsel Robert J. Moody. Is there an announcement in this matter, Counsel?
Judge, it'll be the same announcement. I do believe I've received the discovery in the case. I still need to review it, but I'd like to review it and discuss it with Mr. Chase. And if we can get the June 11th date on this as well.
Court will continue this to June 11th, 2026 at 9:30 a.m. to review discovery. Thank you, Mr. Chase.
Am I coming back here at 2 p.m.
That's
too?
up to you. He has a PFA hearing this afternoon.
Okay, that would be up to you. Who's that with?
Judge Mack, he's got 3 on today.
Okay. Yeah,
Okay, thank you, guys.
all right. And the last one I have for you is SU 2026 CR 91, State of Kansas versus Cody Nelson Yeager. State appears by County Attorney Larry Marchinsky. Is the defendant is not in the courtroom? Is the defendant by Zoom? Is there, I don't see the defendant here. Is there an announcement in this matter, Counsel?
Yeah, Judge, it'll be the same announcement. I asked for June 11th. I have received the written discovery. Still waiting on the video discovery, but just request a 2-week. That way I can get on or sit down with Mr. Yeager, discuss at least the written discovery with him and see what we need to do with the case.
And I'm going to make a note that he must appear as I'm not seeing him here today.
Absolutely. And I'll make him aware of that as well, Your Honor.
I'll continue to June the 11th, 2026 at 9:30 a.m. Defendant must appear. All right. That's all I had for you this morning, Mr. Moody. Is that correct?
That is correct, Your Honor.
Thank you, Counsel.
Thank you, Judge.
I believe Mr. Yoder is on here, maybe? Mr. Yoder, are you ready on your matters?
Yes, good morning, Judge. It's just one today.
Oh. I am only showing one. Who do you?
Miss Daniels is who we
That's
have.
the one I'm showing. Okay. Miss Daniels is present. It's SU 2024 CR 117, State of Kansas versus Taranda Michelle Daniels. Defendant appears in person and with Counsel Christopher Yoder. The state appears by County Attorney Larry Marchinsky. Is there an announcement in this matter, Counsel?
Yes, Judge. This is our first appearance on this one. We'd ask to reset to June the 25th, a date I have some other matters in Sumner at 9:30 a.m.
Court will continue this matter to June the 26th, 2020, June 25th, 2026 at 9:30 a.m. at defendant's request. Thank you, Ms. Daniels, for appearing this morning.
Yeah, I'm first.
It's not shown on my docket, so. Did Bradley get finalized? Because it's not on mine.
After we reset and then we went to a whole bunch of extra effort to move her to the 25th.
Okay, that's
Me
fine.
not realizing I had Miss Daniels today, so that's why
That's
we're
fine,
here.
that's fine. I have nothing further for you either, Counsel. Thank you.
That's all. Thank you, Judge.
Who do we have by Zoom up there? Motorola G. Can't hear you, ma'am.
Keisha Brown.
Wonder why this is at 9:30.
Can you hear me now, Your Honor?
What's your name, ma'am?
Tanisha Brown.
Okay, Mr. Bales is your attorney, and I haven't seen him yet. His normal time is 10 o'clock, so I'm not real sure. It looks like Judge Mott inadvertently set this at 9:30. He'll probably be here at 10, so
So do I come back at 10? Because he
yeah.
told me to, but I called and it said 9:30.
So he did let you know 9:30?
No, he said 10, but when I called, they told me 9:30.
The judge last week said it at 9:30. Mr. Bales is
Yes.
usually here at 10, so you can come back at 10. I'll make a note that you were here at 9:30, but come back at 10.
Thank you so much, Your Honor.
We'll be in recess till we hear from Mr. Bales.
All righty, sounds good. Thank you.
Thank you.
Bye-bye.
Mr. Marchinsky, Mr. Gehring's here in the courtroom with his client. Are you ready on that matter?
I'm sorry, Judge. Mr. Accord, okay, sure.
And I believe maybe the victim is on there. There's a Danae on there, so we may be in compliance with the victim notice as far as the victim being here.
I have spoke with Ms. Smith a few times, and we've discussed potential outcomes here. I know I had spoken with Mr. Gehring, and we had some stuff worked out. I wasn't necessarily aware that we were ready for a plea this morning, but I'm certainly ready to proceed, and I do believe I've complied with the Victim Bill of Rights as would be necessary.
Ms. Smith, is that you that's there on the screen is Danae? That would be my only concern with taking it up early is. Got to go ahead and call it. This is SU 2026 CR 19, State of Kansas versus Bradley Eugene Accord. Would the party state their appearances, please?
Your Honor, may it please the court, Larry Marchinsky on behalf of the state of Kansas.
Bradley Eugene Accord appears in person and through counsel, Alan Gehring.
And is there an announcement in this matter, counsel?
Yes.
To work.
The defendant is entering a plea to the charge of violation of a protective order and is entering a plea of no contest.
Did you get that, Mr. Marchinsky? It's a no contest plea.
Yes, Your Honor, that was the anticipation.
Mr. Accord, you've heard the announcement of your attorney. Is that your understanding of what you're wanting to do here today?
Yes.
And you understand that by entering a no contest plea, you're giving up the right to a trial by judge or jury. And that I'll just hear a brief statement of facts and I'll make a decision on your guilt or innocence based on that brief statement of facts.
Yes.
Okay. You understand at that trial by judge or jury that you'd have the right to require the state to prove you guilty beyond a reasonable doubt. You'd have the right to see the witnesses testify against you. You'd have the right for Mr. Gehring to cross-examine those witnesses. You'd have the right to present evidence and testimony on your own behalf, although you're not required to present any testimony or evidence. You're also giving up the right to testify on your own behalf, but again, you're not required to do that, and we couldn't insinuate guilt by silence. You understand that you're giving up all those rights that you have at that trial? And lastly, you're giving up the right to appeal any errors that might occur at that trial, and you understand that. Okay. Count one is violation of a protective order. That's a Class A person misdemeanor carrying up to 12 months in jail, up to a $2,500 fine. To that charge, how do you wish to plead? State want to provide the court with a brief factual statement?
Yes, Your Honor, thank you. The state's evidence, should this matter have proceeded to trial, the state believes it could have shown through the presentation of exhibits and testimony of witnesses. Essentially, our investigation started on or about January 12th of this year, 2025, when Ms. Smith reported to law enforcement that she had received messages from Mr. Accord in violation of a no contact order. Just to set my basis on that, I'm sorry, I don't have my complaint open. I'll give you that number, that no contact order in a second. However, the evidence would be she showed law enforcement that on 12/28, again on 104 or January 4th, and then again on January 7th, that Mr. Accord had sent her text messages, which would have been in violation of that restraining order. The December 28th text message was something, I don't know if the court wants me to read them out loud. I think I have evidence that text messages were sent. I'm not going to.
I don't necessarily need the context of the messages. The messages themselves would be the contact that violate the PFA. So
Right. They were not threatening in nature. but they were set in violation of a protective order that was in place to prevent those. Again, that being Sumner County case number SU 25DM 261, which was a protection order that was filed in the district court. So that would be the state's evidence of the violation should this matter have proceeded to trial.
Mr. Garing, you agree that the state has at least a
I
minimal
agree.
amount of that basis?
Yes, I do agree the state would be able to put that into evidence if there's case were to go to trial.
Court will find the defendant guilty of count 1 violation of protective order. State have recommendations on a sentence?
Your Honor, based on the, again, nonviolent nature of the messages, I advised Mr. Garing that I would recommend a 6-month sentence. Asked that that sentence be immediately suspended to probation. The only special condition I advised that I was going to request would be no contact with Miss Smith. I would want to state I'm glad that she is here. She did call me either late last week or earlier this week to discuss it with me, a little follow-up. I had advised Mr. Gearing that I was going to request absolutely no contact with Miss Smith. I think that's still her position. Maybe the court would want to voir dire with her. But outside of that, Judge, I'm not requesting any fines or any other special conditions. Just standard terms, court costs, nothing unusual, sir.
Mr. Garing, you have any comments you'd like to make to the court?
I was unclear whether the probation was going to be supervised or unsupervised.
It would be supervised typically. I don't have any problem terminating it early if he's in compliance, and they can coordinate if it needs to be transferred, or they basically dictate how it's supervised, whether it be in person or other. So I would leave it to probation regarding that.
I thought there might at least initially be require some personal contact. Mr. Acord operates his own business, Attica Locker. It's been in the family since 1998. And it would be a burden if it's going to require a lot of travel to Wellington.
Typically, I think they might have, since it's the same judicial district, they would have supervision maybe could be transferred to be done out of Harper County.
We could discuss that with the court.
Yes. Yep.
At that time.
Mr. Accord, do you have any comments you want the court to consider before I impose a sentence in this matter? You're not required to, but you're allowed to.
No, sir.
Court will follow the recommendations. Court will impose a 6-month jail sentence. I will grant immediate probation for a period of 1 year, saying the standard terms and conditions with the special condition that the defendant not have contact with Ms. Smith. Court costs will be assessed. I'm not going to assess any fines. If there are booking fees or other fees, supervision fees, I'll assess all of those. And Mr. Garing's retained, so there's no attorney fees to address. You do have a right to appeal this sentence if you feel it's been imposed contrary to law, and you can discuss that with Mr. Garing. All right. Is there anything further I need to address today, counsel?
I guess the journal entry will include the amount of the court costs and
Yes,
probation fee and
I
everything.
believe so. And he'll need to go downstairs and check in, set up a time with probation today. Do you know where the probation office is?
Is
Yeah,
it
it's
all
not
down the basement?
all the way down, and it's down this back hallway on the south end.
We'll find it.
All right, thank you.
If it's helpful at all, the court cost will be $158 and the probation fee is $60. It will be reflected in the journal entry, of course, but for your information, that's what those numbers will reflect, $158 and $60.
Can he pay that early today, even though there's no journal entry on file? Do we need to wait for the journal entry?
It would be better if they wait for the journal entry, but the clerk should be able to apply it as an unapplied receipt, and then as soon as they get the journal entry, apply it to it. If judge orders them to do that, they will. It would
They
probably
can.
be better to pay it after the journal entry is done, less
We can
confusing,
wait.
but
That's
All
all right.
right.
I just thought he's here and he brought his checkbook. He could get it cleared up. He would like to do that, but if not, that's all right too.
All right, thank you. Thank you,
Thank
Mr.
you.
Garing.
Thank you.
Good luck. Mr. Schoenhofer, I've got a couple of cases with you. Do you have announcements?
All right, sorry about that. I tried to unmute, Judge. I've got a couple of cases, correct. The one that I contacted you on earlier today, or your office, is on the Axel Flores Yamos, I think is how you pronounce it.
Yes.
As I understand it, Mr. Marchinsky has not filed charges yet, so I was just requesting that we set that over for a status hearing on another date.
And I think you're already scheduled to be here on June 11th. Is that right?
Let me
Or not
check.
be here necessarily, but I think you've got one on the dock that day.
Let me take a look at Judge.
I did
I
advise
do.
earlier this morning, the state was going to request that time since I didn't have the charges, but I did advise them that I was going to, 2 weeks on my behalf is what I was going to request, but whatever time.
Okay, yeah, it doesn't matter because no charges are anyway, so yeah. Yeah, the 11th, Judge, and that's at what time?
10 a.m., I believe.
10.
But if
Yes,
you've got,
yes, I do have that time, and yeah, let's do that, Judge.
okay, we'll set that to 10 a.m. on June 11th. And then the other case I have with you is Augustin Guevara Garcia.
Correct, and he is present, Your Honor. I don't really have an announcement on this case, except if to get things rolling, we need to set that for prelim, that's fine. And I know that Larry and I will meet. We've been both busy, I think, and have not conferred on this case yet.
Well, I defer to Mark. I mean, if we want to have a conversation before we schedule it for evidence, that'd be fine. If we want to schedule it for evidence, that would also be fine. I defer to however you want to handle it, my friend.
I was just trying to light a fire under both of us.
I hear you. Maybe we set it off 2 or 3 weeks, Judge, for status, and we can discuss how we're going to go with it, and then we can, if that's okay with Mark, I defer to
That's
him.
fine. Yeah, that's fine.
We'll just set it on that same June 11th, 2026 at 10 a.m.
All right, Judge, thank you so kindly. You guys stay dry.
Yeah. Mr. Bales, I think I saw you walk in. Give me just a second to get your cases up here. Do you have some informal announcements you want to?
Yes, Judge, on Brown, she was on the 9:30 docket. I don't know how she got separated from.
Judge Mott, I'll explain it pretty simply. Judge Mott covered for me last week, and he said it at 9:30. She was here at 9:30. I told her you wouldn't be here till 10, so she's rejoined us, and so.
All right, yeah, as an informal announcement, I'd like 4 weeks on that. I emailed Larry about it this morning. I have good contact with Ms. Brown. We're working on, hopefully resolving that one short of a prelim even. So, I'll know a bit more in a week or two.
And I'm looking 4 weeks is June 25th. Does that work? Is that the date you were shooting for?
I mean, I just stand here and say things. I have no idea what.
We know you're here on the 18th.
Let's see. Actually, the 25th or the 18th would work. Do we just want to stack the 18th?
It's up to you. My dockets are always pretty full, so.
Let's not overload. Actually, no, because I got some stuff in Citrus County at 11. Let's just make the 18th miserable.
Works for me.
Sorry.
We'll continue this to June the 18th, 2026 at 10 a.m. at defendant's request. Thank you, Ms. Brown.
Thank you.
I'll be in touch, Ms. Brown, once I know some more.
Yes, sir. Thank you so much.
Well,
Bye.
I'll leave it to you on the rest because you've got several here in the courtroom. So
I believe, Judge, where did we ever come out with that conflict I emailed you about? How did we resolve that?
which one? I'm sorry.
That was, I was either gonna have Briscoe or.
Briscoe you don't have.
Okay, so I got taken off the Briscoe stuff.
Yes.
All right, so that leaves me with Miss Neal. You hear Miss Neal? All right. Can I get that 6/18 date on Miss Neal?
Yep.
All right.
Did you get that, Mr. Marchinsky? He's
Sorry,
moving Miss Neal's case to the 18th as well.
Thank you.
And Larry, I'll be emailing you on that one too. Who else are we showing? Judge Richardson?
I've got Brandy Dawn Richardson, yes.
Richardson. Can I get the same on that? For some reason, I don't have a file made on that yet, so I'll be getting in touch with you on that.
So I understand that announcement was 6/18 at 10 a.m. as well from Ms.
We'll
Richardson.
continue this matter to June the 18th, 2026 at 10 a.m. at defendant's request. I think quite a few of these for Mr. Bales are new appointments, relatively new appointments, so. Who'd we decide he was gonna get? Sworn.
Yes.
I want to make him aware of that.
Uh-oh. What am I not?
A new appointment.
Okay, who is it?
Mr. Fallsgraf has a conflict on a Paul Osborne. And so when he appears at 11, I'm going to appoint you and I'll put it on that 18th date.
Thanks, Judge. Osborne.
So you'll watch for that. You should get it the next day or two.
Will do. Who else do you have left for me, Judge?
I've got Jason Farley and Christopher Hollis.
All right. I saw Mr. Hollis. Mr. Farley, you here?
Yeah, they're both here.
Why don't we knock out Mr. Farley? I haven't talked to him yet. I
This
haven't talked to Mr. Hollis. We'll knock
This
him
is-
out.
I'm sorry to interrupt you. We need to slow down just a tiny bit. I think that Mr. Osborne and Miss Richardson are either, I believe Miss Richardson might be the co-defendant or I think her
Right,
case is
potential witness.
a domestic battery against Paul.
Yeah.
So I don't know.
I'll find somebody else.
Okay. Okay.
Could we flip flop?
So
Maybe Jorge. Give that some thought, Mr. Marchinsky. I may appoint Jorge to represent Mr. Osborne.
There would be no conflict there. Jorge is completely unrelated, would have never met Mr. Osborne. He'd be really good, I think.
And,
Bailey represented him before and did a great job, but she's about to go on maternity leave. So I
Right.
think Jorge would be a great option.
This is SU 2025 CR 90, State of Kansas versus Jason Thomas Farley. State appears by the County Attorney Larry Marchinsky. Mr. Farley appears in person with counsel James Houston Bales. Mr. Bales, do you have an announcement?
I just need one moment, Judge.
That's fine,
One
that's
last
fine.
Question to answer.
Is he here? Oh, he's okay. That's the one that we thought was tomorrow. So I'll call it. Well, I looked at the judge's notes. Judge's notes saying May 29. It's a CR case that was on traffic last week. Or else she typed it wrong. I gotta get the, I need to get Odyssey figured out for you, because I would like you to look up to see if he has a conflict on Drake Young. Okay. I'll tell him, we'll talk to him when his docket's over.
Judge, at this time, we'd be requesting evidence on Mr. Farley.
Okay, let's, give me just a second. We probably need to schedule that.
I mean, Chris Hollis is with us today. I don't know.
Yeah, I mean.
I'm here.
I understand you're here. I'm just not keen on taking evidence during a docket and.
Well, it's a fairly narrow issue. It's not like this will be some wide ranging, we're gonna go all over the place and need multiple witnesses.
I guess if you're comfortable doing it, then we can do it.
I'm comfortable proceeding.
State will proceed then. It's your motion, Mr. Marchinsky, you may proceed.
Thank you, Your Honor. At this time, the state would call Court Service Officer Christopher Hollis to the stand. Mr. Hollis, you need to be sworn in.
Yep. That's fine.
You do solemnly swear the testimony you are about to give in the case now in hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may proceed, counsel.
Sorry, just trying to figure out what we're talking about here, Judge. Mr. Hollis, what is your current job occupation?
I'm a court services officer.
Here in the 30th Judicial District?
Yes.
And as part of that job, were you assigned supervision of a Mr. Jason Thomas Farley?
Yes.
When was that supervision initially assigned to you, sir?
Oh, October 17th of 25.
It would appear as part of that probation, did you, it appears that you filed an affidavit stating that Mr. Farley has failed to successfully complete treatment. Is that true?
Yes, he was unsuccessfully discharged on May 12th.
Okay, let's back up a little bit. Is his requirement for drug treatment, was that ordered by the court or ordered by the court service department?
By court services.
Okay. And was that, what was the nature, or why was it that court services ordered Mr. Farley to attend that treatment, if you don't mind telling me?
Well, he was going to treatment at Sumner County Mental Health, and then he qualified for inpatient because he had 2 positive UAs for methamphetamine.
Okay. So doing UAs with you, Chris, here at the courthouse, he did 2 UAs and those were dirty.
Correct.
And as a result of that, you ordered him to complete treatment. You said that he was engaging with Sumner County Mental Health, is that right?
That's correct.
Your affidavit indicates failure to complete treatment at PFH in Winfield. Can you explain the difference between them?
Well, one is outpatient treatment at Sumner County Mental Health, and then inpatient treatment is at Preferred Family Health in Winfield.
Okay, I'm sorry, am I confused? Did he successfully complete the outpatient treatment at Sumner County?
No, he did not. They referred him to PFH in Winfield because
Okay.
qualified, because he continued to use methamphetamine.
Okay. As a common part of your job and supervision, do you receive and send out documents? Do you receive documents from treatment facilities advising you whether or not people have complied or?
Yes.
Okay. I'm just asking, how is it that you were advised, or how is it that you know that Mr. Farley did not successfully complete that treatment?
Because I've got a transition discharge summary.
There's an objection. Hold on. There's an objection that's been made.
Objection to hearsay.
Sustained.
Have you had any contact with Mr. Farley since your belief that he didn't complete treatment?
He did report on May 15th.
Okay. When you spoke with him on May 15th, was he currently engaged in treatment at that time?
No, he had been discharged on May 12th.
Objection to hearsay.
Okay, can I further voir dire the witness?
Please.
Okay. When you met with him on May 15th, did he advise you that he was no longer in treatment at PFH in Winfield?
I did not actually meet with him. Our secretary did. He came in and I don't know if she made another appointment for him or not. Let me look in my notes. I think she just told him to appear in court. We don't have a next report for him.
So to be clear, then you haven't spoke to Mr. Farley. He didn't acknowledge to you that he was no longer in treatment. That was the statement made to another person as well.
The reason why I know he got kicked out of treatment is because I've got a discharge summary in my file.
Again, this objection was sustained previously.
Okay.
Judge, I apologize. You wanted to take a little bit more time here. The state should have. I should have called someone from PFH. I don't have any way to admit that document, so at this time I can't meet my burden.
And I'm looking, I'm not seeing a motion on file even. I've got the A and
There's
D.
a motion. I filed a motion to revoke probation on 5/15/26. Unless it hasn't been filed appropriately, I filed a motion to revoke.
That's what I'm worried. I'm not seeing it here in front of me, so Can we just, I'm going to take a brief recess and figure out the motion. If the state wants to set this and continue it, I'm going to allow that. Would you just prefer to do that, Mr. Marchinsky? Just,
I would, Judge. I guess I was trying to rush it a little bit further. I wasn't considering the hearsay nature of it and him not having spoken with this defendant. So I guess I would request probably 1 week or 2 weeks to subpoena the treatment provider to testify as to their statement.
Mr. Bales, are you going to be, next week's not going to be a good week to do this, I don't think.
No, I'm going to be in a murder trial next week.
Right. Are you going to be down here anytime the week of the 8th? I guess I should look at my calendar too.
No, but I don't appear to be unable to be here on the 10 o'clock docket on Thursday. I have a broad availability on Friday, the 12th. If we wanted to special set it, I have.
Mr. Marchinsky, would it be possible to set it the morning of the 12th, like at 9:30?
Yes.
I think at 10 a.m. If we can adjust it to
10,
10.
10's fine.
To give me travel time.
Give me just a second. I got to get back in here. We'll set this motion for evidentiary, or to continue the evidentiary hearing on June 12th, 2026 at 10 a.m.
Can I ask for 10:30? Actually, I was looking at the
That's
wrong
fine.
date. Thank you.
Any objection to 10:30, Mr. Marchinsky?
No, I have the home morning open, sir.
I typically do not mind professionals to testify by Zoom unless there's a specific objection from counsel.
I don't have an objection to that.
Okay.
Thank you, sir. Houston, you might have wanted to talk to me on this one.
Yeah, I'll talk to you.
Give me a call because
Yeah, no, I've
either way.
We'll take this back up then. Mr. Marchinsky, I've noticed that Mr. Cooper has logged into Zoom. Mr. Cooper, can you hear me?
Yes, sir.
This is SU 2026 CR 130. There was some confusion around this case, Mr. Cooper, in that that looked like the judge's notes had you for 9 o'clock tomorrow, but you're here today. We'll take care of this. You have a couple of counts. One's a driving on suspended, third or subsequent offense. That's a Class A misdemeanor carrying up to a year in jail, up to a $2,500 fine. It does have a mandatory minimum 90-day jail sentence, although depending on circumstances, you're not necessarily required to serve that. Count 2 is a possession of marijuana. That's a Class B non-person misdemeanor that carries up to 6 months in jail, up to a $1,000 fine. Count 3 is possession of drug paraphernalia. That's also a Class B non-person misdemeanor carrying up to 6 months in jail, up to a $1,000 fine. And count 4 is also a possession of a controlled substance, marijuana. It looks to be identical to count 2. It's a Class A non-person misdemeanor carrying up to 6 months in jail and up to 25, Okay, Mr. Marchinsky, I'm a bit confused on count 4. I guess this is Mr.
Judge,
Cooper.
the state at this time would move to dismiss that count. I don't know.
Okay.
It does entirely seem to be multiplicitous with count 2. So that
Court will dismiss count 2 at the state's, or count 4 at the
count
state's
4.
request.
Thank you.
Mr. Cooper, you do have a right to an attorney to represent you. If you need a continuance to get an attorney, I'll grant a continuance. If you cannot afford an attorney, the court would appoint one, but you'd need to fill out a application for a court-appointed attorney. Do you know what you want to do regarding an attorney in this matter?
Yes, Your Honor, I would like to continue it so I can have time to find an attorney.
How much time do you think you're going to need?
I would say 30 days if possible.
I will give you one 30-day continuance. I'll continue this to June the 25th, 2026 at 9 a.m. to get an attorney hired. If you realize you cannot afford an attorney, please fill out the application for a court-appointed attorney prior to that time.
Yes, Your Honor.
All right. Thank you, sir.
Thank you.
Mr. Bales has stepped out briefly to visit with the counter. Is Mr. Jester on here from KDOC?
Yes, sir.
I have appointed counsel to represent Mr. Jester. Counsel was unavailable today. They have scheduled that. He coordinated with somebody in the county attorney's office. What was the date on that? Was it June 9th? They coordinated a hearing date for actual evidence or hearing an argument, and I want to say it was June the 9th. We'll get a new notice of hearing out, but Mr. Metcalf has been appointed to represent Mr. Jester, and he's started working on it. He was just unavailable this morning.
Okay.
Is there a good address, email address we can send the notice of hearing to?
An email address?
Yes.
If you give me 1 second, I can get one for you.
Sure.
I'll be right back.
I mean, we can always send it to the address we sent the one today.
Yeah, the physical address here?
Yes, is that work that you received the notice of hearing, I assume?
Yes, sir.
We'll just send it to that address, Mr. Jester.
Okay, that'll work.
All right, thank you.
All right, thank you.
We'll need to do that notice of hearing, Brittany, but we'll have to figure out. Aaron and Matt were in my office and they said it. And I think it was the 9th. I think that was the 9th, Mr. Marchinsky. You already had a few matters set that afternoon, and Mr. Metcalf and Mrs. Zogelman were in my office yesterday, and they agreed to move it to that date because Mr. Metcalf was available. So I'll make sure I get the right times on it, but you've already got a couple that afternoon, so I knew you would be available. I don't think we expected that to take very long, so. Okay.
Hopefully Matt can work with them. I mean, I filed a response. I don't object to what he's
Well,
asking.
he's also filed, yeah, I think Matt just was going to try to get with you and see if you get something, get it figured out. And there was a new motion filed after.
Right. And both of them say, I want relief, but I don't know what relief I'm asking for, Judge. I've told Matt, tell me where he was at. Tell me someplace to follow up. I'm not going to call every county, every jail to figure out where he was possibly at. So tell me where he was at. I'll be happy to look into it. But simply saying, I deserve time, but I don't know what it is, Judge.
Yeah, I think there's something in the file maybe from previous motion. Anyway.
Yeah.
What else do we have on here? Who do we have from the jail?
That's Mr. Root you're on.
Oh, we're waiting on counsel on that one.
And this kind of got short set because we were trying to pursue some other options, and well, we can wait till Bailey gets here. If we're on about a recess, we need to figure out what we're doing with Mr. Hollis, with Mr. Bales, because I need to call Larned and figure out what's going on with Mr. Root.
Right. Mr. Bales just walked back in the courtroom, so. Do you have an announcement of this, or do I need to formally call it?
So we're gonna admit to 2 of the violations, violations 2 and 3.
Okay, let me call it. SU 2024 CR 287, State of Kansas versus Christopher John Hollis. State appears by the County Attorney Larry Marchinsky. Mr. Hollis appears in person with counsel James Houston Bales. You want to announce that again, counsel?
Yes, Judge. At this time, Mr. Hollis would admit for purposes of today's hearing to violations 2 and 3 in the incorporated affidavit that was incorporated to Mr. Marchinsky's motion. We'd request to proceed to disposition today on those.
Mr. Marchinsky, is that sufficient to move forward, or do you want to have a hearing on the remaining allegations? You said 2 and 3?
Yes, Judge.
I guess the first one's alleged for fail to report on the 24th.
I would be satisfied with that stipulation, Your Honor.
Mr. Hollis, you understand that by making that admission, you're giving up your right to a hearing on the allegations?
Yes, sir.
Those two allegations specifically. You understand that you do have a right to a hearing where the state would be required to prove that you violated probation as alleged under those allegations. At that hearing, you'd be allowed to hear the evidence presented, testimony. Mr. Bales could cross-examine the witnesses. You could present evidence on your own behalf, although you're not required to. You could testify on your own behalf. You're not required to. You understand that you're giving up all those rights by making that admission?
Yes, sir.
Okay. And the allegation number 2 is that you failed to report on a rescheduled date of May 1st, 2026. Did you violate probation in that manner?
Yes, and I can explain.
I'll give you a second to do that. And the allegations 3 is that you failed to comply with the repath conditions in violation of probation. Is that also you're admitting that?
Yes, but I can explain that one.
I'll
as
give you
well.
just a second. Court find the defendant has knowingly, willingly, and voluntarily waived his rights to a hearing, that the defendant has violated probation as alleged through his admission, and now we'll proceed to hear dispositional recommendations. Mr. Marchinsky, do you have a recommendation?
Your Honor, I note that there was a recommendation affidavit filed by Chris Hollis, the CSO. It does recommend revoke and remand. It does indicate that this is his first probation violation, but that Mr. Christopher Hollis, the defendant, had only reported one time to sign orders of probation, and that due to his poor performance on bond, that he's just shown that he's not a good candidate for probation. I always support my CSO's recommendations. They're the closest officer to the case and to what's going on. It is typically our policy in Sumner County to give defendants an opportunity based on these situations and based on the probation officer's recommendation. If the court isn't inclined to revoke and remand at this first PV, I would recommend the court consider putting some teeth to a sanction. I would recommend probably 30 days. So again, formally, the state would follow and recommend that the court follow the Chris Hollis recommendation. If you're not inclined to do that, I would request a sanction and reinstate.
Mr. Bales.
Judge, just at the outset, I believe that case law is pretty clear that conduct stemming from before probation can't be used necessarily as a basis to revoke and impose. So while Mr. Hollis admittedly did have a rocky time on bond, I believe it's more proper that we look and focus solely on where we're at as far as the probation itself. So Mr. Hollis's prior experiences with my client notwithstanding. That being said, my client admits that he did not appear on May 1st. That happened after he was on his way to probation, when he was informed through a third party that probation had called this third party and said, hey, you missed your appointment. Mr. Hollis then essentially, realizing he was already in Dutch with the probation officer, knows that he should have rescheduled. That's why we're admitting to that. Knows that he should have made more of an effort, but being already in trouble, he just moved on, continued on to the activity he was going to when he was on his way to stop in and see probation. I believe it was one of his children's sports activities. A violation of repath monitoring. Mr. Hollis's phone disappeared. He believes his stepdaughter, again, a stepchild who knows he's on monitoring and may want leverage against her step parent, may have taken his phone, knowing it would cause problems for him. So, Judge, under these circumstances, Mr. Hollis, we believe he remains amenable to probation. We believe that he deserves an opportunity to show he is amenable to probation. We understand, though, that there do need to be teeth to things. So while we would ask for a reinstatement, the defense would ask for a 2 or 3 day jail sanction and allow Mr. Hollis the ability to schedule that so it doesn't interfere with his ability to maintain employment. Thank you.
Well, I'll let Mr. Hollis explain first, and then I've got some questions. Mr. Hollis, this is your opportunity to make comment to the court. I know you were trying to earlier, but I was wanting to take it up at the right time, and I know Mr. Bales has made some comments on your behalf. do you have some comments you want to make to the court before I make a decision in this case?
Yes, whenever we agreed to this, you as the judge, and you said if I paid it off early, there'd be like 3 months. Well, I go talk to Chris, it's 6 months is what he said, and that's fine. I did lose my phone. I sent an email out because I didn't have, and then I actually called up here, and that's when we got the date rescheduled after onto the 1st. I don't know what the 21st or 24th one is, but like I owe $250 some left to pay this fine, and it is a misdemeanor. I try to get a job, various jobs, and they will not allow me to have my phone on the floor. So I've been working, with just my mother, and I've lost my phone again, and it's no excuse. I do have a phone now. I just want to get this behind me. I don't want to waste any more of your time or the court's time or the state of Kansas' time. I just want to get all this behind me so I can move forward with my life. And as Chris knows, like I was honest with him when I met with him. There is no excuse for me not coming back, or at least making a phone call and checking in and making sure that was what was true, because I didn't do that. That's why I admit to it.
I know he was arrested on a bench warrant. I know he was arrested out of state. Do we know how long he was in custody before he actually arrived at our jail? Our warrant return shows when he arrives at our jail, but it doesn't show when he went into custody on this case. Do we have any idea? I mean, obviously, I have situations often where people don't do well on probation. They're not amenable to probation. And if they're on a felony, I have to do intermediate sanctions. And I've always felt it didn't make sense that I wouldn't do the same thing in a misdemeanor case. So I typically, I know it's against the recommendations, but I'm going to give you another chance to do this right. Okay. And so I'm going to give you an intermediate sanction. The reason I'm asking about how much time you may have done is you may have already done what I would normally do on a quick dip or an intermediate sanction. And so if you've done that time, I just wanted to know how much, if you can. Here's the other deal. And the journal entry does say early release from probation once case is paid in full, because you are in Oklahoma, obviously. Transferring it obviously is not, now is not a good option because we've not done really well on probation, but I don't know that short of a sentence is even eligible for an interstate transfer. And I am mindful that was done. That's a little bit different than we normally do, that you get the case paid off and you're done. So I am going to impose a sanction. I'm not going to do a 30-day sanction. I'm going to do, like a 5-day sanction, give you credit for whatever few days you may have done and let you schedule the other part of that sanction, whether it be 48 hours. And then your probation is going to be reinstated on the same terms and conditions. Your attitude is going to be very, very important over the next few weeks. Okay. I'm going to hold to, if you get that paid in full, you get back on probation, you do the sanctions, and you do what you're supposed to do for 30 days and get it paid off, that case should be terminated. This case has been going on since 2024. And I know primarily the reason it's this old is you had a number of failed to appears, not considering the bond supervision, my decision on your probation. But this case got drawn out primarily because of issues that are similar to this. Understand, I'm not holding that against you in my decision today, but that goes a long way. If we don't have any other problems, you'll be off probation. If we have other problems, you're going to serve the rest of your 6 months. I'm just going to be flat simple. Any violation, I'm giving you a chance today. Your attitude's a lot better today than it has been in the past, and I definitely appreciate that. So that's going to be my orders. We'll need to sort out how much time he did, because I know he was arrested in Oklahoma and had to be picked up, and I don't know how many days it took for him to get to the jail here. And then he bonded out.
Local charges, not picking up May 20th.
So he's already served the sanction. You need to go downstairs, report to court services, get your next appointment. All right. You need to do what you've got to do. Get this case paid off. If you and Mr. Hollis don't agree to termination, contact Mr. Bales. He's got ongoing appointment. He can file a motion with the court and I can address whether to terminate your probation.
Thank you, sir.
All right?
Your Honor, was this
Yes.
extended for 1 year today? Was it extended?
I'll extend it for, well, he's not been on that long.
Okay.
I'm not going to extend it. It's going to be from the original term, or we'll just call it 6 months from today. But my hope is you're not on for 6 months. My hope is you do what you need to do and we get it done, get everything paid off, stay out of trouble, report, do everything you're supposed to do, and we get this terminated.
Judge, in my understanding, your order was for a 5-day jail sanction, but you're giving him all credit for time served. He doesn't need to serve any sanction. Is that
Correct. I think, according to Deputy Brown, he served about 8 days when he got picked up on this.
Okay.
But I still want to call that a sanction for the records so that if we are back here, I can see that I've actually sanctioned him. And then we'll proceed. Hopefully, we're not back here on a motion to revoke. All right? This hearing's concluded.
No, you have an absolute right to an appeal. Do you want your appeal? No. So what we're gonna do, we're gonna cover waiver on that. So an appeal basically is just double checking the judge's work by a higher court. In case you probably won't even get a hearing, which is real pleadings, you would get an attorney and transcripts at no cost to you. If you change your mind about 14 days, you let me know. I can file your appeal after that deadline has passed. If you're able to tell me if you make that decision, it gets much harder or even impossible to get your appeal back. Nothing prevents you from pursuing another form of post-conviction relief, like the motion you were talking about. And this doesn't apply to you because this was on trial. You don't want an appeal, correct? No. Right. Today is the 28th of May, 26, and then sign below. Yeah, works for me. Sign there. All right, man. Go check in with probation. Yep, thanks.
We have Mr. Root from the jail. Is that all you had, Mr. Bass?
I believe that's it for me, Judge.
Thank you. You will be getting a new appointment, but I can't tell you who it is yet.
Oh, okay.
Mr. Fallsgraf had a couple of conflicts. And so
Thanks. 21-618. I'll knock them all out.
that's the plan.
Thanks, Judge. I'm gonna borrow your library and do it here.
All right. Thank you. This is SU 2024 CR 299, SU 2024 CR 222, State of Kansas versus Damon Errol Root. State appears by the County Attorney Larry Marchinsky. Mr. Root appears from the Sumner County Jail with Counsel Bailey Schmiedler. I know we'd set this on a short situation. Mr. Marchinsky, I know you have not had an opportunity to contact Larnard. Thoughts?
We were, unfortunately, it's been crushing lately, Judge, and I'm sorry. Bailey and I had been working on some other potential housing issues. I know I made a record last time that we're getting to a situation where even if Mr. Root were to be found guilty by a jury of his peers, he is getting close to maximizing any sentence that he would suffer as a result of the behavior that he has alleged against him. He has been awaiting a competency bed at Larned for, I mean, Bailey can correct me, but 15 plus months now. So we were trying to explore some other potential housing options here in Wellington. To be honest, Judge, I haven't had a time to flesh that out with Miss Beggs or with Sumner County Mental Health. Of course, as we learned last week with another defendant, the housing options that they're providing currently is the Oasis Motel. So that's not a great option. I do apologize. I had intended to call Larned. I hadn't had an opportunity to call them a week ago or 2 weeks ago to figure out where Damon was at on the list. Last time we talked, he was still 50, something like that. He started at 100 and something, so he has made progress, but it's slow. If the parties want to take a 5-minute recess, I can try to reach Charity Duff at Larned. She's usually very responsive. Otherwise, the state would just have to simply request, I would say 2 more weeks, but to be honest, Judge, and knowing my calendar and what I have coming up, nothing will have happened in 2 weeks or very little. So I would defer to Bailey, maybe 3 or 4 weeks. But that's where I'm at. That's what the state would have as far as an announcement.
Counsel, you have, I don't mind taking a break if we want him to, Mr. Marchinsky, to make that phone call. It's up to you.
That's fine. Fine with me.
We'll take a 5-minute recess. Ms. Hess, I see Miss Brand is on here. I need to reach out to the clerk. Okay, she's on there. So we'll take a 5-minute recess and I'll get I'll be right back. We'll resume Mr. Root's hearing. Mr. Marchinsky, do you have any further announcement regarding?
Your Honor, I was luckily able to get a hold of Charity Duft. Unfortunately, she does the care and treatment side of things. She was able to punch in Mr. Root's name and advise me that he's now 39th on the list, so he has dropped about 15 spots since the last time I got an update. However, Charity could not advise me anything further. She transferred me to Miss Wilder, who does the competency, but I was not able to speak with her. I got her voicemail. So the only update that I can give over what I've said previously is that Mr. Root is now currently 39th on the list, awaiting a competency bed at Larned.
Do we just, I mean, I don't think we have any alternative but to set this over. It's just a question of when.
Judge, I've been typically requesting 30 days at a time on behalf of the state to keep this on the court's docket. I guess that would be my request again, and I will make the statement again. I will try to seek out other housing opportunities and try to get Miss Lauren Beggs involved, but that would be the state's request.
Ms. Schmiedler? That'd be like June 25th if you're available that day. And I know you may or may not be, but
Yeah, June 25th should be fine.
okay. Court will continue this to June 25th, 2026 at 10:30 a.m. And I've made pretty extensive notes on that. And counsel, I also have a Xander Aiden Muglia.
Yes, Your Honor, he should be in the courtroom.
Oh, yes, he's sitting in the back. He just stood up. I'll make a note. He's present. That's SU 2026 CR 137, State of Kansas versus Xander Aiden Muglia. State appears by County Attorney Larry Marchinsky. Defendant appears in person with counsel Bailey Schmiedler. Is there an announcement in this matter?
Yes, Your Honor, we've reached a plea agreement with the state and are ready to proceed with that this morning.
Okay. If he'll come forward, give me just a second. I'm having him come to the table. Is this going to be a felony plea that we need to waive or?
Yes. He'll be pleading to count 2. In exchange, the state will dismiss the remaining counts.
Okay, you've heard the announcement your attorney just made? You heard the announcement your attorney just made that you're prepared to enter a plea today?
Yes.
Okay. You understand you're charged with a felony, and with that charge comes a right to a preliminary hearing. You understand that at a preliminary hearing, the court would hear evidence to make a probable cause determination as to whether you should be bound over on a felony or not, and that you will be waiving that right, that if I didn't find there to be probable cause, you'd be discharged on the felony counts, and if I did find there was probable cause, you'd be bound over on any felony counts I may have found probable cause. You understand that you're giving up that preliminary hearing?
Yes, I understand.
And it's your intention to waive a preliminary hearing today?
Yes.
Okay. Court will find that he's waived a preliminary hearing and ready to proceed to an immediate arraignment. Do we need to do a formal reading?
No, Your Honor, we would acknowledge receipt of the complaint, waive formal reading, and just ask to proceed with the plea agreement.
And you indicated count 2, is that correct?
Yes, sir.
Mr. Muglia, you understand you have a right to have me read your charges to you, and your attorney's advised that you understand what you're charged with and that you don't need me to read those to you. Is that correct?
Yes, that's correct.
And the announcement is that you're pleading guilty to count 2 involuntary sexual relations, which is the level 9 person felony, and the other charges are being dismissed, I presume.
That's correct, Your Honor.
Mr. Muglia, you understand you have a right to a trial on that charge to a judge or a jury?
Yes.
And that by entering a plea of guilty, you're giving up that right to that trial by judge or jury?
Yes, that's correct.
Okay. And you understand at that trial, you'd have the right to see the evidence the state has. You'd hear the testimony of the state's witnesses. The state would be required to prove you guilty beyond a reasonable doubt. You would have the opportunity to have your attorney cross-examine those witnesses. You'd have the right to present evidence and testimony on your own behalf, although you're not required to present any defenses to the court. You also would have a right to testify on your own behalf, but you could not be made to testify, and you could choose to remain silent, and there could be no presumptions made regarding that. Choosing to remain silent, you understand you're giving up all those rights that you have at that trial?
Yes, correct.
And you've had an ample opportunity to visit with your attorney about this, and you're comfortable that this is how you want to proceed with this case?
Yes.
You're also giving up the right to appeal any errors that might occur at that trial. You understand that?
Yes.
To the charge of involuntary sexual relations, how do you wish to plead?
Guilty.
Okay. And the allegations on or about the 30th day of April 2026 here in Sumner County, Kansas, that you did engage in a unlawful voluntary sexual relations or act with a victim that was
She was 15 at the time, sir.
that's what I was looking at, a 15-year-old victim, and you're less than 4 years older than that, which would constitute that charge. That's what the state's evidence would be.
It would be that Mr. Muglia and Miss Wynn, him being 19, her being 15, engaged in sodomy. And that would be a consensual relationship, but it's still unlawful because of the ages.
And I recall reviewing the probable cause affidavit, if there's no objection to that. Ms. Schmiedler, you agree that that would be the state's factual basis for going forward on this charge?
Yes, Your Honor.
Court will find the defendant has knowingly, willingly, and voluntarily waived his right to a trial, that he has entered a plea of guilty, that there's a factual basis for the court to accept that plea, and the court will find the defendant guilty of count 2, unlawful voluntary sexual relations, a level 9 person felony. State have a motion regarding the other charges.
Would move to dismiss those charges with prejudice, sir.
Court
No
dis-
objection.
Court dismisses counts 1 and 3 with prejudice. We'll need to schedule this for sentencing and have the appropriate pre-sentence investigation reports provided to the court. Court services want to chime in and let me know how much time you think we're going to need. Somebody from court services? I know we normally.
Judge, I would just recommend 4 weeks. This isn't SB 123. There shouldn't be any necessary special evaluations or anything that need to be done. So 4 weeks should be ample time.
Counsel,
We can use the 25th. That
yeah,
would be
that's
great.
what I was wondering. We'll set this for sentencing on June the 25th, 2026 at 10:30 a.m. Mr. Moogly, you'll need to make and keep all your appointments with court services to do that. You'll need to go check in with them now so that you have contact and you can make an appointment for them to start that. Do you know where the court services office is?
Yes.
Okay. Oh, you're on bond supervision. Okay. That bond will continue with the additional condition that you make and keep all appointments with them. So go check in with them today and they'll get that started and we'll be for sentencing on the 25th.
Okay.
All right. Thank you. And I believe that's all you had, counsel. Is that correct?
Yes, sir. Thank you.
Thank you. Sorry for making you wait, Ms. Hess. This is SU 2025.
Thank you for allowing us to appear today.
This is SU 2025 CR 42, State of Kansas versus Angeline Renee Brand. It looks like the court had set this over, held the warrant from last week. She is appearing by Zoom. Ms. Brand, do you want to activate your video?
Yeah, I'm here.
Is there an announcement this morning, counsel?
Yes, Your Honor. It is Ms. Brand intends to enter into a plea agreement with the state, entering a plea of guilty as charged to count 1 of the complaint.
Give me just a second.
Thought we were pleading to count.
Huh?
Thought we were pleading to count 3.
Count 3. I may be wrong. I don't have the paperwork up in front of me. I apologize.
Okay, so this will be a waiver of a prelim as well.
That's correct. Let me pull this up before I.
Let me double check our emails as well, that I'm not forgetting something differently.
Before I shove my foot further into my mouth. Nope, I'm sorry. That was count 3.
That's the possession of methamphetamine charge, right?
That's correct.
And the state.
And I believe that all other counts were being dismissed.
Is that correct, Mr. Marchinsky?
It is, sir, yes.
Okay. Ms. Brand, you understand that that is a felony charge, correct?
Yes, I do.
And since it's a felony charge, you have a right to a preliminary hearing. And at that preliminary hearing, I would hear evidence. And if there was not enough evidence to bind you over on a felony, or there was not probable cause on the felony, you would be discharged on the felony charge. And that if after hearing the evidence, find that there is probable cause to bind you over on that felony or any other felonies, that I would do that. And you are at this point wanting to waive your right to a preliminary hearing and proceed to an arraignment in this matter?
Yes, sir. I'm just trying to get
Right.
all this court shit done.
Court will find the defendant is knowingly, willingly, and voluntarily waived her right to a preliminary hearing. Ms. Hess, does the defendant want a formal arraignment on that?
No, Judge. She's willing to waive formal
Right. Ms.
arraignment.
Brand, basically your attorney's advised you have a right to have me read your charges to you. She's advised that you know and understand what you're charged with and you do not desire a formal arraignment. Is that correct?
Yes.
Okay. The charge in count 3 is possession of methamphetamines, a level 5 drug felony. You do have a right to a trial by judge or jury on that charge, and that by entering a plea of guilty, you're giving up that right to a trial by judge or jury. You understand that?
Yes, sir.
And you understand that at that trial, the state would be required to prove you guilty beyond a reasonable doubt, that you would have the right to see the evidence, hear the testimony of the state's witnesses. You'd have the right to have Ms. Hess cross-examine those witnesses. You'd have the right to present evidence and testimony on your own behalf, but you're not required to present any defenses. You'd also have the right to testify on your own behalf, but you're not required to do that either. And the court couldn't insinuate any kind of guilt because of your choosing to remain silent. You understand you're giving up all those rights to that trial?
Yes.
You've had ample opportunity to visit with your attorney in this matter. Is that correct?
Yes.
You're satisfied with the services she's provided to you in this case?
Yes.
Are you under the influence of anything at this point in time? Are you taking any drugs?
No.
No alcohol, no drugs.
Nope.
Okay. You understand you do also have a right to appeal any errors that may occur at that trial, and you're giving up that right by entering your plea of guilty. You understand that?
Yep.
To the charge in count 3, possession of methamphetamines, how do you wish to plead?
Guilty.
And on or about the 29th day of October 2023 here in Sumner County, Kansas, it's alleged that there was a possession of methamphetamines. Is that the state's factual basis through the testimony of Deputy Rick Shaw and the KBI that is the basis for me to accept this?
It would be, Your Honor. It would be subsequent to a traffic stop and a search that there was some crystal substance found in the vehicle that was sent off to the KBI for lab testing and tested positive for the presence of methamphetamines.
And Ms. Hess, you agree that's the state's got that minimal amount of
Yes,
evidence?
Your Honor.
Court will find the defendant has knowingly, willingly, and voluntarily waived her rights to a trial. The court will find that there's a factual basis for the court to accept her plea of guilty and find the defendant guilty of count 3, possession of methamphetamines. State have a motion on the remaining charges.
I do, Your Honor. Would ask to move that those remaining counts 1, 2, remind myself here, 1, 2, 4, be dismissed with prejudice, sir.
Court will dismiss counts 1, 2, and 4 in this matter. Court will schedule this matter for a pre-sentence investigation report, LSIR, probably 6 weeks.
This one would be 6 weeks, Judge. It is anticipated to be SB 123, not drug court because of residency, but I do believe it will be SB 123 eligible.
Ms. Hess, are you available on July the 9th?
Let me check.
How does that work with me being on probation with the SB1 or whatever in Sedgwick County?
And you'd have to talk to Lucy, but typically we would agree to transfer and it would just be one probation.
And
If the judge
And we can
granted
talk
that,
about that
they-
offline, Angeline.
Yep.
Does July 9th work, Ms. Hess?
That does work.
Court will set this matter for July the 9th at 10:30 a.m. Ms. Brand's to be present in court in person at that time. Ms. Brand, your bond is modified for you to make and keep all your appointments with court services so that the appropriate pre-sentence investigation reports can be made. So you need to contact them today to set up your appointments to have all the evaluations done. You understand that?
Yes, sir.
All right. Is there anything further I need to address today, counsel? Mr. Hollis, do you have something you wanted to add? I just saw that you turned on.
Yes, Your Honor. We would like for her to report in person to the Sumner County Courthouse today, to the probation department.
Did you hear that, Ms. Brand?
Yes. I'll try and I'll get there.
All right.
Yeah, be here by 4 o'clock, please.
All right.
All right.
If there's nothing else, this hearing's concluded. Thank you. And I believe that's all you had, Ms. Hess. Is that correct?
That's correct. Thank you for working me into your docket this morning.
Thank you for helping us. All right.
Judge, I do apologize. I anticipate Austin's docket's going to be a little bit brutal. Can we have a 5-minute comfort break? We've been going since 9. I just need a few moments.
Yes, we'll take a short break. Resume when you come back.
Thank you, sir.
No, I just got done.
Are you ready on your case? Was I unmuted? Mr. Vinduska, are you ready on your case? Well, once he comes on, we'll take his case up. Oh, here he comes.
I can certainly be ready.
Do you have an announcement or is?
We're just going to continue it for a status. I did talk with Mr. Hubbard about it. A couple other follow-up questions he had that I'm going to follow up with you.
Okay, and what date do you want that continued to, Mr. Vinduska? Mr. Vinduska, are you still there?
Yes, I don't know when I switched over to my calendar, all of a sudden kind of kicked things off.
All right.
Looking for a Thursday morning, is that correct?
Yes, Thursday, any time of day, basically.
Okay. Tell you what, I could do June 25th in the morning.
What time do you want
Right.
that set at?
How about 11 a.m.?
Court will continue this matter to June the 25th, 2026 at 11 a.m. at defendant's request.
Perfect. Thank you.
Thank you. Okay, Mr. Falsgraf, you tell me.
Sounds good, Judge. I think most of these I can burn in turn before we get into formals. My first case I would like to call would be Kimberly Rowley.
Miss Rowley's present. What's the announcement on this case?
Judge, I've been working with the county attorney, coordinating with victims. Progress is being made here. I would request if we could get this out to June 25th at 11, we should have some progress.
Court will continue this matter to June the 25th, 2026 at 11 a.m. at defendant's request. What do you have next, Mr. Falsgraf?
Really quick, I don't think it's going to go today, but it'd be set over for disposition, Miss Teague.
That's, give me just a second. Issue 2025, Sarah 258, State of Kansas versus Michelle Teague. You have an announcement in this matter, Mr. Falsgraf.
Judge, we are prepared at some point here in the near future to plea. As this court knows, there is a fair deal of codependency between husband and wife here. We anticipate them to plea on the same day, and we believe his next court date to be June 25th. So for that reason, we are requesting June 25th for disposition.
Court will continue this matter to June the 25th, 2026 at 11 a.m. for disposition.
You need to be ready to plea that day. Okay. We're taking too many continuances as is. All right. I'll plan on seeing you then. If you have any questions, feel free to stop in. Okay. Judge, I also have a Mr. Chauncey Thomas here.
That's a relatively new appointment for you, counsel. Do you have an announcement in that matter?
It is, Judge. My client's done a good job staying in contact with me. He is here today on his first appearance. For these reasons, we're trying to work probably towards the diversion track, and I've got a good faith belief he'll stay in contact with me. I'd request a little longer than I normally would, so we can hopefully get the ball rolling without need for many appearances. I would request July the 9th, if I could.
Court will continue this to July the 9th, 2026 at 11 a.m. at the defendant's request.
Obviously go to the clerk's office like we talked about. Have to work with them. You might call me later this afternoon or Friday, and we can coordinate getting that license back together. Okay. Have a good day. Thanks for being here.
I see Mr. Osborne here. We probably need to address
do
that. Mr. Osborne, if you'll come up, this is SU 2026 CR 41, SU 2026 CR 53, SU 2026 CR 61, State of Kansas versus Paul Eugene Osborne. State appears by the county attorney Larry Marchinsky. Defendant appears in person with counsel Austin Fallsgraf. Mr. Osborne, Mr. Fallsgraf has indicated, as he's worked through discovery, that he has a conflict in at least one of your cases. And so I'm going to need to reappoint counsel. It's just more efficient if the new attorney takes all the cases because those are typically worked. So we've appointed Jorge De Hoyas to represent you, and we'll get him the information. What date was it we looked at? So we're going to set this to June the 11th. Actually, did you say the 25th? We'll go to June the 25th, 2026 at 1:30 p.m. is his normal time. You give it a few days, like next week, reach out to his office and set up a time to visit with him.
Okay. Okay.
All right?
All right,
So
thank
stay
you.
in touch with your new attorney.
Thank you. Yeah, I will. Thank you.
Do you have some up there? You've
I wasn't anticipating some. I do know Melanie Ray's in the courtroom here today, and I do anticipate a continuance there.
Okay.
If we want to.
We'll take her case up. What's your announcement in that case?
Judge, discovery's been provided in this case that wasn't in the initial batch. It was provided a couple weeks ago. I just need to sit down and have the time to review that with my client. For that reason, I would request the 25th if I could.
Okay. Court will continue this matter to June the 25th, 2026 at 11 a.m. at defendant's request.
It'd be in your best interest to get me called early next week. Okay. Have a good day. Thanks for being here.
Ms. Bram, that was that's one we've continued. It's not, you haven't got it yet. Ms. Bram, come on up. Ms. Bram, the county attorney has not made a charging decision on your case yet. So he's asked for 2 more weeks to consider that. You haven't been appointed an attorney because the case hasn't been filed yet. But he asked for a couple more weeks to give him a chance to decide what he wanted to do with that case, if he wants to charge it at all. So I'll continue it to June the 11th, 2026 at 11 a.m. That's correct, right, Mr. Marchinsky?
Yes, Your Honor. Thank you.
Thank you, Ms. Bram. Okay. Are you ready on that one? That's Ms. Schomer, right?
One more.
Continue. That's fine. This is SU 2025 CR2, SU 2024 CR228, State of Kansas versus Raina Nichelle Schomer. State appears by the county attorney Larry Marchinsky. Ms. Schomer appears in person with counsel Austin Fallsgraf. Is there an announcement, Mr. Fallsgraf?
Judge, there's been, we have a decent idea where this case is headed. It's likely headed to a revoke and remand. In the interim, for this court to be able to consider My client has been attempting to get, she believes she's paid off all restitution in this case. She believes by end of week, we could have all fines paid off in this case. And we are also, I gathered some potential credit for time served for this court to consider. My client has informed me that one of my dates, the longer day that I would be requesting, although it not be court ordered time, was off by a big number. And so I want to have an accurate number to reflect, to be able to provide this.
I saw the email and questioned that myself because I've never seen a treatment that was long.
I think a good chunk of that was outpatient treatment and it was lost in translation. With that being said, in order to coordinate these things, I would request 1 or 2 weeks, whatever works best. If we want to make it 2 weeks to avoid this jury trial docket date, that'd be perfect. And that'd give my client a little more time to get everything paid off for this court to consider.
And when I saw the email, obviously communicated it to Mr. Marchinsky and myself, I would prefer any request for that time served, some written documentation, if you can get that.
I
would
can try
prefer
to,
that
certainly.
before I consider it. I'm not prejudging whether I'm going to do it or not, but something more. Court will continue this to June the 11th, 2026 at 11 a.m., expecting this to be resolved by that time.
Judge, I know it doesn't help, and I'm not going to ask you to change what you've already done, but formally the state is going to go ahead and object to the continuance here. This PV has literally been pending for 4 or 5 months. I think the initial motion to revoke her probation was, I don't even know, it was in February, maybe. I'm trying to find the first document. So and I appreciate what Austin's doing, and but formally, I thought we were going to get through that today. I thought we were going to make arguments on the time served. I didn't see his email this morning. We've been backed up. So I'm not asking the court to change what you've already did, but I would ask the court to notate that it is over the state's objection at this point. We need to get this moving.
I understand that. And I'll note the state objected.
That means in 2 weeks we're going no matter what. Okay. So I have everything wrapped up.
All right, this hearing's concluded.
Call me next week early so we can start coordinating and I can coordinate with Austin. Okay.
Judge, I'm sorry. My initial motion to revoke probation in this matter was filed in August of 2025. So this PV has been pending for 10 months now.
And there's been a supplemental filed in the last 60 days, so. You're getting her whittled down, Mr. Falsgraf. Is Miss Nicholson, I know we've got some people logged in. Is Miss Nicholson one of the people logged in on Zoom?
Yes.
Ma'am, you need to activate your video, please. Mr. Falsgraf, do you have an announcement in these matters?
Judge, these are relatively recent appointments. I spoke with my client this morning. We're planning to meet and sit down and hopefully work through these things. I would request, given it's a new appointment and June 11th is getting hectic, June 18th, if we could.
Court will continue this matter June 18th, 2026 at 11 a.m. at defendant's request.
Ms. Nicholson, did you hear your next court date?
Yes, I did.
It is imperative that you keep staying in contact with me. I'd get me called early next week if you can, and we'll sit down and meet and talk about these things, okay?
Okay, thank you.
Is that Mr. Richardson?
So they couldn't get me in this morning.
Yes, sir.
That's fine.
It's packed, so
We
I'm
can-
gonna plan on special setting.
This is SU 2025 CR 146, SU 2024 CR 273, State of Kansas versus Bobby D. Richardson. State appears by the County Attorney Larry Marchinsky. Defendant appears from the Sumner County Jail and with counsel Austin Falsgraf. Is there an announcement in this matter, Mr. Falsgraf?
Judge, I was unable to meet with my client this morning. There are some considerations I wanted to go over with him prior to either requesting a contested hearing or stipulating to the alleged violations. I know next week's getting rough with the jury trial date, but if there is a special setting date, I can make something work. I defer to this court and the county attorney. I don't want it to linger too long, but I think we're getting close.
Mr. Marchinsky, I know we've got, Mr. Falsgraf, you're scheduled for sentencing on June the 9th at 2 p.m. I don't know that that'd take a tremendous amount of time. Do you want to do it after that? And I leave, if the state's got an issue with that, you can let me know, Mr. Marchinsky.
No, I think June 9th is fine.
I will try to tip my hand as to what it is I anticipate we will be doing. So if for some reason I have an indication that will be a contested hearing, I can try to let the state know ASAP. I know it might just be Mr. Hollis that would be required at a contested hearing. They might need someone from Sumner Mental Health. I'd defer to the county attorney, obviously, on that, but.
And I'll explain what I did earlier today, and I'll do it for mental health as well. I typically allow the professionals to testify via Zoom unless there's a written objection or some type of objection to that. So I'm going to set this for June the 9th, 2026 at 3 p.m. And if we get done with your sentencing sooner, we can always take it up. I don't see any reason that we would need to wait till 3 p.m. unless Mr. Marchinsky has witnesses.
I mean, that'll be anticipating whether Austin wants an evidentiary hearing or not. I've made a
I'll
plea
let you know
essentially to
either way.
avoid that, but we'll see what happens. But that date's fine, sir. We'll get it taken care of.
This hearing's concluded.
Mr. Richardson, I'll try to be out well before that time to see you, okay? I just couldn't make it out this morning. They were booked.
All right. This is Mr. Young. It is.
Yeah, I think so. I believe so. It is.
This is SU 2026 CR8, SU 2026 CR 132, State of Kansas versus Drake Allen Young. State appears by the County Attorney Larry Marchinsky. Defendant appears from the Sumner County Jail, and Counsel Austin Falsgraf appears in person. Mr. Young, Mr. Falsgraf has discovered through discovery that he has a conflict in this matter. And so I'm needing to appoint other counsel to represent you in these cases. I'm going to appoint Houston Bales to represent you in these matters, but I'm going to need to set them over to give him a chance to get the appointment paperwork. And he's very diligent about getting in touch with you as soon as he receives his appointments. So I'm going to withdraw Mr. Falsgraf. I'm going to appoint Mr. Houston Bales. I'm going to need to set this over. I'm going to continue to June the 18th, 2026 at 10 a.m. And Mr. Bales will be out to see you. And if he needs to see the court before that date, then he usually is pretty good about getting with me and Mr. Marchinsky and getting a special setting. So he'll be appointed on both matters.
Okay, Your Honor.
This hearing's concluded. Thank you. I've got a Bryce Simmons. You were appointed on that. She just didn't add you to the freaking case. Oh, am I on? Yeah, you just got appointed on that one. May 15th. No, I did that in court. Okay. Are you ready on Miss Archuleta's cases?
It's going to be really similar to Bobby's now.
This is SU 2026 CR 57, SU 2026 CR 56, State of Kansas versus Cynthia M. Archuleta Phelan. State appears by the County Attorney Larry Marchinsky. The defendant appears from the Sumner County Jail and with counsel Austin Falsgraf. Is there an announcement in these matters, Mr. Falsgraf?
Judge, just as a brief background, this court's well aware that at the onset of these cases, I had requested both a competency eval to be accompanied with a mental health assessment in the interest of if a plea was to be offered with hopes for AOT court. Since there's been some turnover at Sumner Mental Health, and I've now been working with a Lauren out there.
Beggs.
I've been in touch with Lauren as of this morning. I plan on getting her all the orders sent, so hopefully we can get that going. Given the recent failures to appear, I anticipate that any bond modification request I had or would make would be falling on deaf ears. So with all that in mind, I would like to set this over for the 9th. Hopefully by then, we at least have that in the process. If not, if it's not fully done, I don't see anything that would preclude us from being able to take a plea at that time. In hopes that in the near future, then we would at least have an assessment on file. So we're not taking as long to get to sentencing in this case, Your Honor. So I would request a special setting around the same time as Mr. Richardson on June 9th at 3.
Court will continue this to June the 9th, 2026 at 3 p.m. at defendant's request. And if we want them transported, we just need to let them know.
If we could get them transported, that would be ideal.
What's the,
Okay. I've indicated the deputy will get we'll get him transported from the jail to court.
No, we just have to have the order.
I just ordered it, Brown.
Did you put the date down? I'm sorry.
June the 9th, 2026 at 3 p.m.
that was to transfer to court for appearance?
Yes. There does. I'm not going to require a formal transport order. And if the sheriff wants that, he and I can have a conversation about that.
Judge, we have a few times talked about having the sheriff transport folks over to mental health for evaluations to facilitate those
No,
things. So I was
that's
just,
the court. That's the court.
okay, understood. Thank you.
I think Deputy Brown may have been snoozing here in the courtroom and didn't catch that.
And I do believe Miss Beggs, for what it's worth, is based on my initial conversation, going to make it out to the jail to speak with her to do the assessment out there.
Right. All right. There's nothing further. This hearing is concluded. And Mr. Falsgraf, I have one last case for you. It's an SU 2026 CR 133, State of Kansas versus Bryce Allen Simmons. And I appointed you 2 weeks ago, but I'm not seeing that you, and there's an order of appointment in there, but I'm not seeing you got added to the case. So it probably didn't show up on the docket with your name. And so probably need to set that over to give you a chance to reach out to him. I will let you know he is hearing impaired.
I think I'm aware of this individual. He appeared last docket with me. And in fact, that makes sense because Dad, who helps him out a lot, my client is it's a little more than just hearing impaired. They were expecting docket today, and I said, you guys are not on the docket today. So there's some confusion there. I told him I'd reach back out if for some reason he was on the docket today. So he has been in contact with me. We've been working through some things to get this case in a better spot. With all that in mind, I would request the 18th if I could for that case.
With your statement that he's been in touch with you, I will continue this to June the 18th, 2026 at 11 a.m. at defendant's request. And I'll make sure that that case gets added to your cases so that it shows up on the docket sheet that gets sent out with your stuff on it.
And I think I said it, but they called and they said, hey, what time is court tomorrow? And I said, you do not have court. You do not have to show up. So they're not appearances on me, nothing to do with them.
I'll note that you must appear at that next appointment. I'm not showing any other cases.
I'm showing one more unless we already covered
Who
it.
is
It's in
it?
a long enough docket. Did we get Kylie McEachern? McCurch?
Yes.
We did. Okay.
Yes. I think that was in your list of continuances to July the 2nd.
Okay.
Yes, she showed up. I used your email.
Yes.
And continued it and told her they'd get hold of you.
Thank you, Judge.
All right. Thank you. We'll be adjourned.